there is a problem with the light as well. This one. If they can move it, they can shift it a little bit. Okay. Did they interfere with it during the lunch break, or was it like that before lunch? Or did you not notice?
No, the fact that I didn't complain speaks to my resilience, Chairman.
Okay. Okay, they will try and attend to it, but I must just make sure they understand what you suggest should be done. Should it point this way, a little to the left, a little bit, or?
Yes.
Okay. Okay, all right.
Okay.
Okay. Let's make sure it's fine first. How does it look like now?
Yeah, it's okay. It's okay, Chair.
Okay, all right.
Yeah.
Okay, let's continue then.
Okay.
Thank you.
Thank you, Chair. We're at paragraph 7.3
7.3
of your statement, Dr. Mufamadi, where you say that the panel probed deeply and widely into the issue, and I presume the activities of special operations.
Mm-hmm. Yes.
And you also refer to an investigation conducted by the Inspector General of Intelligence into the activities of the Special Operations Unit.
Mm-hmm. Yes.
Who was the head of Special Operations at the relevant time? Or you refer to him as the key player?
Yes, during the period under review, the special operations was led by Mr. Lomo.
Is that Tulani Lomo? There are two Lomos.
Yeah, Mr. Tulani Lomo.
Right.
Tulani Lomo.
And then in paragraph 7.5, you say a little of his background. I don't think we need to go there unless you feel it is important to do so.
Sorry?
In paragraph 7.5, you deal with Mr. Lomo's background.
Yes.
I say it's not necessary to go there unless you feel it's important to do so.
No, it's not necessary.
Right. Did Mr. Lomo testify before the panel?
Yes, he did.
Was he a good witness?
In our reckoning, he was the most difficult witness because he was uncomfortable to answer some of our questions, and to justify his reluctance to answer those questions, he invoked the need to know basis. And we thought he didn't quite understand that this is a panel established by the president. You can't be an operative of the state organ, and when the state wants to do some introspection in an area where you are operational, you invoke the need to know basis.
It's like you are doing your operations for yourself, not
yes,
for the
as
state.
if you are doing your operations for yourself. Yes.
To put it differently, did Mr. Lomo give a full and frank account of the activities of special operations?
Well, by the time he came to the panel, we had already had other members of the Special Operations Unit who appeared before us. And when we were trying to test some of the things that were said to us before he came, his need to know defense, so to speak, stood in the way we think of him fully cooperating with the panel.
All right.
Yes.
Paragraph 7.7.
Well, I don't know whether you, Dr. Mufamadi, whether you particularly didn't want to be categorical in terms of the answer to the question as formulated by Mr. Pretorius.
Yes.
But if that is the case, but he was effectively asking whether he gave his evidence before the panel, in your view, or in the view of the panel, in your view, frankly and candidly and cooperated fully?
No, we didn't get his full cooperation.
Yes. Okay.
Yes.
Okay.
In paragraph 77,
7.7.
sorry, 7.7,
Okay.
yes. You say certain matters became clear to the panel on reviewing the evidence, and you drew certain, at least preliminary conclusions. What do you say in paragraph 7.7 in regard to what you discovered about the operations of the State Security Agency Special Operations Unit?
Yes. What we say in that operation, or rather in that paragraph, is that the special operations, in our view, carried out some operations which were unconstitutional and illegal, and that there is a sense in which that unit was a law unto itself, that is relative to the management structures of the SSA, because they were not reporting, following the reporting line. From what we were told, some of the more senior people than Lomo, for instance, would say, we were not getting reports from the special operations. We were told that, we report as special operations to the executive, and therefore we can't report to you. The money that was disbursed on request for operations, according to the relevant people in the chain of management, they used to have what they call the TA system. I'm trying to recall what TA stands for, but it's an advanced
TAS, Temporary Advanced Systems.
Temporary Advanced Systems. It was a cash-intensive, transaction-based work. But besides that, you would then have huge amounts of money, which we will talk to later, which were allocated on a regular basis for projects. And the financial accounting people would say, we did not get reports in which people were accounting for that money. Then, as you will see, some of the operations were sort of really misdirected in that they were looking at things to do with, I'll call it political intelligence, running the projects in an inappropriate manner, in that principles such as political neutrality and so on were not observed. To the extent that we kept on talking about the findings which relate to the weaponization of intelligence for wrongful political reasons. those had to do mostly, as we were investigating, with what the Special Operations Unit was doing.
The management that was saying there are these individuals who, as far as we are concerned, are supposed to account to us, to report to us, who are refusing to report to us, or who are saying we can't ask them certain questions because they report directly to the executive. As a result, we don't know what they are doing, or we don't know what they are doing with the money that they get given. Did they say that they raised those issues with the executive? And if so, did the executive side with those people and said there was nothing wrong, or was this something that your panel did not explore?
We did not explore, but you know, in general, you would have expected people to say we made representations to the executive. But if people don't say we made representations to the executive and they were coming to us to tell us about how helpless they felt, then you realize that there was something wrong there.
You see, why it's important to establish that is because sometimes you could have a situation where those people who, as far as they know, are the people to whom reports should be coming from certain people, see this and see that it's wrong as far as they know, in terms of how the organization is supposed to work, to operate. But they are scared to raise it with the executive. So they just sit. And when the panel comes, they pour out their frustrations, but they've never raised it. But you could have a situation where they have raised it. And if they have raised it, it would be interesting to know what the response of the executive was. So that's why I was asking.
Yeah, sure. I think this matter must read together with that term of reference we were talking to
Earlier
about the directives relating to manifestly illegal instructions.
Yes.
Because it's difficult then to expect people to raise questions when they see wrong things being done, when they did not raise these questions, when the step that is, the initial step which leads to this was not questioned.
Yes. Because if, for example, they didn't raise those issues, one might ask the question why they didn't. It may be that when they get given a chance, they could give reasons that one understands. But it may well be that they give reasons and one says, but this is not the type of leadership in an organization that should be there. So going forward, maybe certain characteristics of leadership should be looked for this type of positions. We don't want people who are not going to raise issues they should raise. At least they should raise them and see whether they are not being helped or not.
Yeah, sure. But you see, I think that now we are talking with the benefit of hindsight.
Yes.
We realize that they did not raise this. The question is whether there was an enabler in place. So if we are recommending that there should be directives that address these issues, we are really raising issues of empowerment, where people can say, I heard the chair saying, can you give me an instrument I could have used to help you? In the absence of such an instrument, people are disempowered.
Yes, but the point I'm making is the first step is to talk to them, to say, you are telling me that you have had these problems, where people that you know to be under you and are supposed to report to you when you ask questions about what they are doing, they tell you that they don't report to you, they report to the executive. So I'm saying the first thing is to ask them, if you didn't raise it with the executives, why didn't you raise it? Then they can say, here was the environment that I found myself in. Maybe I found it intimidating, or the minister was this type of person or whatever. Or they might say, well, I actually did raise it, and this was the reaction. Or I raised it a number of times, he kept on saying, we'll talk about it. After some time, I realized that he was never going to engage with me on it. So that's the level, to say the start is just to find out whether there was a desire and a commitment or courage to raise, but maybe the environment was not good, or there were other reasons.
Yeah, well, maybe I need to say, which is really outside this report,
Yes.
that the establishment of the panel seemed to be, have been received roundly within the SSA very well. So, you know, people would say to you informally, we welcome this initiative. And then they tell you what they've seen, which they hope this initiative will help solve. You know, we are afraid to raise issues and so on.
Yes, yes,
But
yes.
you couldn't put that in the report, these things that are said to you informally.
yes.
But we were sufficiently sensitive to the fact that people wouldn't just voluntarily come forward and say, I don't think this is the right way to do this. And generally, you would know, Chair, as a labor lawyer.
Once upon a time.
Once upon a time, yes. That workers would always want to protect their job security and things like that.
And I wouldn't be surprised if the environment in the intelligence community, which seems to be dominated by secrecy, might not be very empowering or might not be very conducive to people maybe asserting certain rights. I don't know, you know.
Sure.
Because I don't know whether things can happen and it's difficult to get redress elsewhere, you know. I don't know. But I wouldn't be surprised if that environment is not the best environment for people. Yeah. Okay.
Sure.
Thank you. Mr. Pretorius?
So by way of introduction to the evidence to come, Dr. Mufamadi, you say in paragraph 7.7 that it became clear to the panel that the Special Operations Unit was a law unto itself and directly served the political interests of the executive, and that's what you mean by weaponization of the service.
Yes.
You also say that the Special Operations Unit undertook intelligence operations which were clearly unconstitutional and illegal, and we will deal now with some of them. Obviously, these are not all, as you say, but the first is Project Construção. It's a Portuguese word with Portuguese spelling, and we'll inform the stenographer accordingly. Chair.
Well, I thought, Mr. Pretorius, you would, I thought on a light note, you would say whether the chairperson can give you the correct pronunciation of this one.
I'm sure you could give the correct pronunciation. But I even took the trouble of asking our researcher to tell us what that C was with a squiggle underneath. It's a cedilla, and the A with a squiggle on top is a tilde.
Oh.
So if that's of any interest to anybody, that's the spelling of Construção. What did that project involve?
Yes, maybe it's another illustration of what is meant by the unit being a law unto itself. You see, it is the constitutional responsibility of the South African Police Service to provide what is called VIP protection, protection for political office bearers. Then the first thing that was wrong that was done by this unit was to organize the training of undercover agents in VIP protection.
Before you go there, and if we can just take a step back to what you said about the duty of the South African Police Services to provide VIP protection, to whom would the persons providing that protection be accountable?
Ultimately, it's to the Commissioner of Police.
Yes, right.
Yes.
And in this case, that would have been avoided. That accountability line would have been avoided.
Yeah, once this function is being carried out elsewhere, then it means you are bypassing the structures of the reporting structures of the police.
And they become accountable to SSA operatives and the person receiving the benefit of the protection, as I understand it.
Yes, firstly, as you say, they are then accounting to the structures of the SSA, and the SAPS is out of the loop. But also, you need resources to carry out that function. The budget of the SSA ought not to provide for that function, because there is a sense in which there is double dipping. Whatever these undercover agents do may well be a duplication of what the SAPS believes itself to be doing. But also, you can imagine that sort of stampede that happens when there is a parallel provision of VIP protection service.
Yes. In any event, I interrupted you. My apologies, Dr. Mufamadi. You say undercover agents were trained.
Yes.
We needn't mention where, but in a foreign country. Did you know that?
Yeah, that's what we were told, that they were trained in a foreign country.
Why would there be a need to train undercover agents in a foreign country to protect the beneficiaries? And we'll come to them in a moment.
Well, maybe let me put it this way. Really, it's an operational discretion on the part of the leadership of an organ which has got that responsibility to determine where the people are to be trained and by whom. And I'm saying, as I'm emphasizing this, that is the responsibility of the police.
Yeah.
They may feel...
For which training is available in South Africa, I presume?
Well, they may feel in some cases that there is a benefit to be had from accessing elements of training which they may not have. I'm saying they may feel that way. Right. But I am saying it is not within the competence of the SSA to make that determination.
But just to go back one step on what you were saying earlier on, one, that it is the responsibility of SAPS to provide VIP protection to, for example, political office bearers. And saying when somebody else provides VIP protection without being under SAPS, then they are bypassing the structures of SAPS, to which they should be they should account. But of course, you could have a situation, I would imagine, where SAP members are being used to provide protection to certain individuals, maybe who are not entitled to that protection, but it is SAPS members that are being used. And whoever is instructing them, who is outside of SAPS, make sure there is no reporting to the job structure of SAPS. That's one scenario. Another scenario is where the people who are providing protection are not SAPS people in the first place. Obviously, in that scenario, you can't even talk about bypassing the SAPS. They should not be there. They should not be doing that at all.
Sure.
Is that right?
No, sure, they should not be there.
Because they are not SAPS in the first
Because
place.
they are not SAPS.
Yes.
But as you say, Chairperson, there may well be people who are provided with VIP protection services. And they don't fall within, shall I say, the
Approved categories.
approved categories. It is still the responsibility of the SAPS on the basis of threat analysis to make a determination of who are these people that do not fall within the defined category, who should be given protection.
Yes.
Now, you will see that there are people who do not ordinarily fall within these defined categories, who were provided with protection by the Special Ops Unit, which is another transgression of basically the law. I mean, we are a law-governed society. You can't have a function as sensitive as this one being a free-for-all activity.
Yeah. Okay.
Well, you make 2 points in paragraph 7.8, and we'll come to the detail in a moment. The first is that undercover agents were trained under the auspices of the SAA in VIP protection.
Yes.
And these were then assigned not to everybody across the board, but to only certain select individuals, some of whom fell within the category of those deserving of VIP protection in the ordinary and proper course, and some who didn't. That's the second point you make. Who benefited from these private protection services, or perhaps let's not use the word private, but special operations protection services?
Well, we were told by people who came from the SAPS to meet with us that they received reports that to the effect that you would have instances where the President of the Republic was traveling. Now, when a person who falls within this defined category travels from, say, from one province to the other, or sometimes going out of the country, particularly the President, you will have what is called an advance party. People who go ahead and look at the situation and make sure that everything is in order. We were told that there were instances where these people who are going from the SAPS as the advance party, they would collide into people who say we are from SSA, Special Ops, we are here to look after the interests of the President. That is one. Then you also had, and this was confirmed now by the Special Ops people that we also interviewed, you would also have people who did not ordinarily fall within the defined category, who were provided with these protection services. I don't know if, in terms of your agreement,
No, you can, this has been approved.
I can mention,
mention
the
the
names.
names.
Yes. I've seen the chair dealing very harsh with people who don't ask whether they should mention names. Okay. You had people such as the former chairperson of the board of South African Airways, Ms. Dudu Mieni, the former national director of public prosecutions, Mr. Sean Abrahams, the ANC Youth League president, Mr. Colin Maine, and the former acting head of the Directorate for Priority Crime Investigations, General Yolisa Matataka. Now I'm relying on memory because I don't know why this does not appear here. I spoke about the president then of the ANC Youth League. These services was apparently provided also to the then deputy president of the ANC Youth League. The SAPS was not able to tell us that they had a threat analysis which justifies protection by the state of these individuals. Yes. You can say on the face of it, maybe the director of public prosecutions, but who makes that determination matters, yes.
Yes, there will be further evidence regarding this project, but we understand it's been terminated. Paragraph 7.9, project commitment, what was that about?
Yes, your records will show the ones that will have been provided to you by SSA, because I don't have the name offhand of an operative from Special Operations who, or maybe let me put it this way. For each of the projects, there was an identifiable individual who went to the window, as it were, to receive money disbursed for that project.
And it would always be the same individual or one individual?
No, one individual per
transaction or per taking?
Per project.
Yes, no, what I mean is you have, for example, here project commitment. So what I'm asking is whether project commitment would have one individual who would be responsible to collect funds for
Yes.
all operations of project commitment, and you have project VESA.
That's
and,
right.
you have one person who would have that responsibility. It wouldn't be different people.
That's right.
Okay.
So once we had the possibility to talk to, or let me put it this way, we were given documents before we started our work in terms of interaction with people. So by the time we started our work, we knew about this project. We knew who was receiving money on behalf of what project. And we were interested, at least without asking them to give us documentary evidence, we were interested to know, what did you do with this money? And then with project commitment, we were told that that project involved providing then president with 2.5 million rand per month.
Then President Zuma.
Yeah, well, you'll see the year per month in the 2015-2016 financial year. That's President Zuma. And this amount was increased to 4.5 million rand per month in the 2016-2017 financial year. And the allegation there, at least to the extent that we were just told this, apparently this money was provided via then Minister Mahlobo. The person who gave this information was saying, yes, I'm certain that the money was given to Minister Mahlobo, but I cannot prove that it was received by President Zuma.
But was his evidence before your panel that the understanding in the money being given to Minister Mahlobo, that he would pass it on to President Zuma, was that?
Yes, yeah.
Was that
he understood that this was the final destination.
Yes. Okay.
Without claiming to have witnessed.
Yes, yeah.
Yes.
Yeah, okay. Okay.
Two issues arise out of that the panel was told. The first is that a minister appeared to be involved in the operations of the State Security Agency to the extent that it was intended that money handed to the minister would be handed on to President Zuma.
Oh.
Correct.
Yeah.
I take it we don't need to debate the propriety of that.
No, we don't have to debate the propriety of that.
Yes, but let's maybe it might not be as obvious to everybody listening as it might be to Mr. Pretorius and to you,
Point taken,
Dr. Mufamadi. You were a minister in cabinet for many years.
Yes.
Would you know of any circumstances where monthly, because that seems to be what you say this person told you as the panel, monthly a minister was given such large amounts like 2.5 million rand for a whole financial year, 2015 to 2016, and then 2016-2017 it increased to 4.5 million rand every month. Would there be circumstances when a minister needs to be given any money other than his salary?
I must say that's unthinkable.
Yes.
Yeah, that's unthinkable, and I don't know of such an instance.
Yes.
I can cite my own experience. I never received such money.
Yes.
Yes.
And you never had, throughout all those years that when you were a minister, you never heard of a minister who received?
Maybe I was in government for too short a time because it was just 14 years and 8 months.
But now, did this person who gave this evidence to your panel say, I see here that it says per month, but was your understanding that he was saying actually every month during these 2 financial years? He was the person who took, during the 2015-2016 financial year, 2.5 million rand every month and gave it to Minister Mahlobo for onward passing, as he understood it, to President Zuma. Was it an every month occurrence, as you understood it?
Maybe let me put it this way. I suppose the commission will be able to find someone at SSA who says, we made this disbursement.
Yes.
And the person who says they received it.
Yes.
Indeed, they received it from us.
Yes.
But again, coming back, they did not tell us what happened to the money.
No, I accept that.
Yes.
But I'm just talking because from what you say here, it looks like the person that gave evidence before the panel that you are talking about, from whom you got this information, seems to have been clear before the panel that he or she knew that the money was given to Minister Mahlobo.
Yes.
And it says 2.5 million rand per month in the 2015-2016 financial year. That seems to suggest to me that it must have been monthly, but that's my understanding.
Sure.
So, and then in the 2016-2017 financial year, it kind of doubled. It was 4.5 million rand, again, per month, So at least as far as that was your understanding of his evidence or her evidence, whoever.
Yes.
Yeah. Okay, all right. And did you say this was cash?
Yes, it's a cash-based.
It was a cash, these were cash transactions.
It's not these things that they call electronic transfer.
Yeah, it's
or
not
a check.
electronic
No,
transfer
no,
or a
it's
check.
cash.
Yeah, it was cash.
Yeah.
Okay, all right.
Yes, the second point that is evident from what you say in paragraph 7.9 is that no proof was given to you that the funds were actually given by Minister Mahlobo to President Zuma. So at a very basic level, the project could have been, as far as you are concerned, executed as per its intention and the money given to President Zuma, or the money trail would have stopped with Minister Mahlobo, with all the implications that arise from that.
Yes, we have no
Equally serious.
We have no basis to say it was given to President Zuma or it wasn't. Yes.
But I see that apparently you were told that there were acknowledgements of receipt of these funds by Minister Mahlobo.
Sorry?
I see that you say in paragraph 7.9
Yes.
that I think the person who gave evidence before your panel seems to have said that there were acknowledgements of receipt of these funds by Minister Mahlobo.
Yes.
Yes. And do you have a recollection whether these may have been made available to you to see or not really?
No, they were not.
But he said the receipts were there.
Yeah, they were not. And as I said, we were really not extending the investigation.
Yes, you were high level.
Yes, we were high level.
No, that's fine.
There will be further evidence.
There will be further evidence.
But I presume you would agree that in either case, whether the monies were kept and withheld by Minister Mahlobo, contrary to the intentions of the project, or whether they were given to President Zuma in accordance with the intentions of the project, it's a matter worthy of investigation.
No, it is a matter worthy of investigations. As I said, this kind of practice is unheard of in government. Yeah.
Let's deal with the next project, Project Justice. What was involved here?
Well, this is a project which ostensibly involved recruiting and handling sources in the judiciary in order to influence the outcome of cases against President Zuma.
Right. Now, before you go on, recruiting and handling sources, would this have been payment of monies?
Sorry?
Would this have involved payment of monies?
Well, information provided to the panel indicated that amounts of 1.2 million rand and 4.5 million rand were routinely given from SSA and provided to Minister Mahlobo, whom it is said was responsible for handling these sources.
And these sources were whom? What category of person?
The panel was told that this project was motivated, as I said, by a perceived need to counter the influence of judges hostile to President Zuma. Allegations made were to the effect that judges were bribed to achieve this purpose. This should, however, we thought, be treated with extreme caution, as one would not want to be party to the destruction of public confidence in the judiciary. That's what we thought, and I'll explain what I mean by that, because we were not provided with any actual evidence that the operation was actually carried out to conclusion. And if you want me to elaborate, I will.
Well, there will be further evidence, but let's just deal with the issue of sensitivity.
Yeah.
One acknowledges, without qualification, that this is a sensitive issue
Yes.
and that it should be handled with caution,
Yes.
because public confidence in our judiciary and the independence of our judiciary is of prime importance to our constitutional democracy.
Sure.
All that one can accept. But if there is an attack on what might be termed the most valuable element of our constitutional democracy, that's an independent judiciary, this commission is obliged to deal with it, and the public have a right to know. Would you agree with that?
Absolutely.
And what must occur then is that, to the extent that it has been investigated, this matter should come before this forum in public. And secondly, if investigations haven't been concluded, they should be. Do you agree with that?
I agree, but I must add this caveat that on a matter of this gravity, we must refuse to be gullible. Given everything that we've said about this unit and its work. Because if we run ahead of ourselves, we will put the house on fire. And one African-speaking friend of mine used to say that they have a saying in their community which says, don't start a fire which you may not be able to put off.
Yes.
Yeah.
Yeah.
So, very important that we approach this matter with circumspection.
And obviously one shouldn't let a fire rage behind closed doors.
No, sure. But also don't go in public and put fire.
No, I understand that.
Yes.
But if the matter was before the panel,
Yes.
this was contained in the unredacted report, or the redacted report even, as I understand it. No.
I don't
Well,
think
certainly
we
the
have-
unredacted report. But
Yeah.
be that as it may, I don't want to go down that sideshow.
Okay.
Let's just, whilst the matter is before the commission, it is a matter of sensitivity, but it is a matter of utmost importance that it be dealt with and thoroughly investigated. And that's perhaps something we would present to the chair in due course. You would agree with that?
Yes, but I hope you also agree with me when I say approach this matter with an open mind.
Yes.
Because I think we had a sense that some of the operations could have been a ruse for money-making undertakings.
Yes, we'll come to that in a moment.
Okay.
I think I understand completely what you are saying
Yes.
in terms of how it should be handled. I think you are saying, while obviously anything that deserves to be investigated should be investigated, at the same time, we mustn't fall into the trap of giving credibility and credence to something that might have no credibility
Sure.
and credence whatsoever.
Sure.
It's a balancing of the two
Sure.
considerations. You don't want not to investigate what may be genuine, but at the same time, you don't want to give credence to something that has no credence at all. It's just how you strike the balance.
And it's a delicate balance.
It's a delicate balance.
Yes.
Okay,
Sure.
all right. Mr. Pretorius.
Let's assume, for the purposes of the next questions then, Dr. Mufamadi, that this project was not carried out, right? it was conceived. We know that.
Yes.
It was thought of by operatives and perhaps senior people within the SSA. And money was attributed or given to this project. That in itself would be very serious.
No, sure. I mean, if you have a person whose imagination carries them that far, and they are in the SSA, then we are in trouble. Just the imagination. Then I'm saying we are in trouble. And you therefore need to get to the bottom of it, whichever way.
Yes, yes. And there will be further evidence, and we'll explore whether there has been a full investigation.
Sure.
Or whether the fruits of the investigation have been disclosed to the Commission. But that's another issue that will be dealt with in due course. But let's go to the other proposition that you raised, on the assumption that the project wasn't carried out.
Mr. Pretorius, I'm sorry. I should have raised this while we're dealing with 7.9. So, in terms of arithmetic, so in the 2015-2016 financial year, it would therefore appear that if the evidence of the person who gave evidence to the panel that Minister Mahlobo was given 2.5 million rand every month, so over 12 months, that would have been around what? Around over 20 million?
Over 60 million. 4.5 times 12.
No, I'm looking at the first one, 2.5.
30 million.
Well,
You're
about
testing
30
my
million.
maths.
Yes, so then the 4.5 would probably be around 60 million.
54.
54.
Yes, but Chair, it depends, particularly with the first year,
Yes,
on when exactly in that year did this practice start.
of course,
Yes.
of course, yes. Well, one would have to check here, but nevertheless, large
sure.
amounts,
Sure.
large amounts. Okay, I'm sorry,
Yes,
Mr.
and the
Pretorius.
totals are on the assumption of the full year.
Yes, yeah.
Sure.
Let's just go back before we summarize Project Justice, Dr. Mufamadi. You raised the possibility in paragraph 7.10 to point 2 that this whole project was a ruse, albeit a very imaginative and creative ruse, to obtain state resources. In other words, it was merely a cover for the theft of money from the fiscus. Is that correct?
Yes, but as you say, it's speculation. Yes.
Speculation and its probabilities
Yeah, sure.
can be debated, but
Yeah.
it would seem a rather elaborate and dangerous ruse to conceal the theft of money. But that would be an equally serious allegation. Well, not an equally serious allegation because it doesn't have the constitutional implications that the project would have if it had been carried out. But it's serious in the sense that we're instructed that at least 24 million rand was involved here. You create a cover and you steal 24 million rand and you hand it in cash to Minister Mahlobo. That's a...
Yeah, there are many elements of...
That's a rather far-reaching, I would say,
Yeah, no, sure.
proposition.
But as you say, I mean, the manifest illegality of just the action itself, but also the principle of the separation of powers.
Could you say a bit about that, please?
Sorry?
Could you explain
Yes,
that
I'm
to
saying the
chair?
independence of the judiciary, you forget about it if this project was indeed implemented. So it's not just whether there was an illegality, there is a more fundamental issue of whether our system can still be relied upon to deliver on what it exists for. If an arm of state, the judiciary loses its independence.
Yes, the point I think that you are making, if I can put it to you, is that broadly speaking, there are a number of constitutional checks and balances built into the Constitution that deal with the judiciary and make the judiciary itself accountable in many ways. To have a secret agency of government funded by the fiscus to interfere in the independence of the judiciary in a manner which is unaccountable is simply unconscionable. Would you agree with that?
So unconscionable, but then, our brief was to try and understand if we find that there are things that went wrong, how did they go wrong when you've got such checks and balances provided for in our system of government, our constitutional democracy. Anything that suggests that there was a subversion of independence of any one of these organs of state, or even just contemplation of that subversion, is a matter of grave concern.
Well, this evidence that the panel was told is quite concerning in terms of if these things are true, if they did happen. I mean, I've been sitting here, well, not all the time, but we were sitting in another venue in 2018 and 2019 as the commission, but I've been hearing a lot of evidence over the past 2.5 years. And so from what you are saying here, and I get the sense from Mr. Pretorius that maybe there will be other evidence, it's not the first time that I hear evidence or that I may be hearing evidence to say so-and-so says he used to give money to so-and-so to pass on to President Zuma. I had evidence like that from Mr. Agrizi, saying that monthly Busasa or Mr. Gavin Watson gave money to Ms. Dudumieni to pass on to Mr. Zuma. I don't know whether it was 100,000 rand or 300,000 rand, but some money. There was no evidence, there has been no evidence that that money was received by Mr. Zuma. But I'm just saying, when I sit here, I remember other evidence that I've had. So here I'm saying that this would be the second time I hear evidence of that nature. Okay, Mr. Pretorius.
Is the reading of paragraph 7.10 correct, that the sources referred to in the judiciary are in fact judges?
Yes.
And that allegations were made to the effect that judges were bribed to counter the influence of judges hostile to President Zuma? That was what you were told?
Yes.
But you say there was no actual evidence that the operation was carried out, and we've dealt with it to an extent, at least, on the basis that such a project could ever have been conceived.
Yes, but as I say, it was not our place to dig deeper than that.
And we're at idem, are we, that this is a serious matter warranting the fullest investigation?
Sure.
We know that Minister Mhlobo gave evidence or spoke to or was interviewed by the panel, correct?
Yes.
And we've been given access to a recording of the interview he had with the panel. Unfortunately, that recording is entirely corrupted, and we're trying to see what we can do about it. But perhaps you can help us. Do you recall whether this series of factual allegations under the head Project Justice were put to Minister Mhlobo?
Yeah, as you say, it's really unfortunate that the part of our hearings which was covered was recorded, and it's not us who recorded. I'm talking about technically we learned was corrupted because I would have asked for that myself so that I could then, without relying on memory, say, these are the questions we put to Mr. Mhlobo and this is how he responded. So I have no recollection of questions we put to him in this regard and how he responded. Yes. I would rather suggest that the Commission find a way of taking these matters further with him.
Right. Let's move on then to Operation Lock, paragraph 711 of your statement. As I say, Chair, there will be further evidence in this regard. Operation Lock. What did this project involve, at least insofar as you were told?
The name Eugene de Kock, depending on where you see it, it's famous or infamous. Now, Mr. Eugene de Kock spent some time in prison, and he was subsequently released, apparently on the basis of a memorandum of understanding with the Department of Correctional Services. I don't want to go into details about what actually occasioned that. Was not a matter within the brief of the panel.
We needn't go into much detail here. There are sensitivities around it.
Sorry?
I say we needn't go into much detail in relation to this project.
Yes.
Safe to say that SSA provided him with a safe house and protection.
Sure.
And when on release from prison, who would normally bear the responsibility for the protection and provision of safe houses, if necessary, to a former prisoner? Would it be SSA?
Well, I did not have sight of the memorandum of understanding to start with. But logic would say to me, if the memorandum of understanding was between Mr. de Kock and Correctional Services, they would have committed themselves to ensuring that he is protected, that he has got a place to stay, if he did not have one himself. That is Correctional Services. If they needed the assistance of a sister department as far as protection is concerned, one would have thought that the appropriate department to ask for assistance from its SAPS. So we don't know why it was SSA.
Let's move, sorry.
Yeah, we don't know why it was SSA, but we came also to understand that, I don't see the exact amount here, but there was an amount of money that was advanced to Mr. de Kock for his upkeep whilst he was out of prison, protection afforded. And if that was the case, the question is then, why was that money provided for by SSA? But I guess the appropriate person from SSA will answer this question.
Yes. Yeah, I won't say any more, but we are operating in consultation with the SSA and in regard to the extent of the evidence that is given.
Yes.
7.12 Project WAVE, would you tell the Chair what that project involved as far as you learnt
Sorry.
and was told?
Sorry.
Paragraph 7.12.
Yes.
Project WAVE. Would you tell the Chair, please, what that project involved as far as you became aware?
Yes, we were told that this project involved infiltrating and influencing the media at home and abroad in order apparently to counter bad publicity for the country. And the then president and the SSA. In other words, in the opinion of SSA, there was bad publicity in the country, within the country and beyond, about the country, about the president, and about the SSA, which then necessitated this infiltration and influencing of the media. So they say the project was launched in the 2015-2016 financial year with a budget of 24 million rand. And they say one of the largest amounts issued for this project was 20 million rand given to a media agency, apparently therefore for services rendered for 8 months.
Yes, it was originally intended that the name of the agency would be redacted, but you've had discussions with the SSA in that regard, and it's not necessary to redact the name. What is the name of the agency?
The agency, we were told, is Africa News Agency.
Then paragraph, well, and we know, don't we, that there is already a legitimate arm of government that deals with publicity in relation to government and government activities. Correct?
Sure.
Yes. Paragraph 7.13, Project Accurate or Project Kusela. What was this project about?
We were told that this was a project to recruit toxicologists to test the food and bedding of then President Zuma. This project had an initial allocation of 500,000 rand per month, which increased to 1.5 million rand per month in the 2015-2016 financial year. And again, we did not understand this to be the responsibility as a panel of the SSA to deal with issues of toxicology and related issues.
Yes, one doesn't want to make light of this, but we do have evidence which may well be presented to the Chair that one of the fruits of this toxicology unit's efforts was to discover expired cool drinks in the pantry of the former president. Do you know anything about that?
No, we were not told about expired cool drinks and that it costs so much to discover.
Well, exactly. That's the point, I think, and that evidence will be given.
Expired cool drinks. I always check also myself whether cool drinks have expired, and I don't spend money to
Perhaps
check.
you won't need so much money to check that.
I don't have it. Maybe it's because of that. Yes.
Yes, but I think the point is, although lightly put, the point is that it was an expensive project.
It was an expensive project indeed.
And then Project Tin Roof, what was that project about?
This, we were told, involved an investigation into the alleged attempted poisoning of President Zuma by his wife, Mantuli, but it also involved acquiring a safe house for Mantuli and seemingly maintaining her, given the quantum of the project budget of 5.2 million rand, with a monthly withdrawal of 800,000 rand.
Right, so just to summarize so far in relation to the former President Zuma, we have evidence of a project to provide a security force for his benefit.
Mm-hmm.
We have evidence, at least prima facie evidence, that amounts were allocated for his benefit of between 2.5 and 4.5 million rand per month. We have evidence of a toxicology unit being created and paid for his benefit. And we have the amounts expended in relation to his wife, Mantuli. There's further evidence that you will deal with where he benefited from certain projects conducted under the auspices of SSA. But what would you say to that collection of evidence in relation to the state security, human security divide?
Well, I think the point that you were making, the observation you were making, I concur with it. These are extraordinary expenses. Financing extraordinary undertakings on the part of SSA. Now, to the extent that some of them come up as for the protection of the president, and as you correctly said, Chair, I was Minister of Safety and Security for a period of 5 years. I was not involved in operational issues. But these issues that are being aired here are not just operational, they've got strategic implications. And faced with such issues, or similar issues, the Commissioner of Police would have deemed it necessary to bring these issues to my attention. At no point were we told that these issues were brought to the attention of the Minister of Police, because that would have been the relevant minister. And the department for which he has got political responsibility would have been the appropriate department. And issues about toxicology and so on would have involved consultation between the SAPS and possibly the Department of Health or some such department. So you can see why I am saying there are many questions that this thing, it begs quite a number of questions which possibly will come out in the wash.
Were you told what the justification was, at least from the point of view of SSA, for giving or arranging for a safe house for Mantuli? She was not an agent Was there anything really advanced to the panel to say, well, as the relevant unit of the SSA, which did this, this is how we see it as justified. This is our we think it's justified because of ABCD.
Like with other projects,
Yes.
we were not provided with what I would consider a cogent, logical explanation
Yes. Yes.
for why, if there were challenges in these sort of areas, it was then the responsibility of SSA to step in. Yes.
Yes. But as you recall, you were given you were told something that they considered to be a justification, but you didn't consider it sound, or you might not have been given an answer at all.
Yeah, we might not have been given an answer at all. As I said, I don't have proper recollection of that.
But nothing sound,
yeah,
as far as
also,
you're concerned.
yeah, also, Chair, you will appreciate that if we tried to follow everything to the last detail,
I accept, yeah.
we were given actually 6 months
Yes, no, I accept.
to complete this task.
Yeah, you had to be careful about not spending too much time on individual items.
Yes.
You needed to get a globular picture.
Yes.
Yeah, okay.
In paragraph 7.15, Dr. Mufamadi, you deal with certain information you were given and things you were told in relation to particular projects involving civil society. And you mention at least 2 here. What were they?
Yes, there are two issues here, interrelated. The one we were told about was testimony, and there were legal papers that were provided which speak to that issue, about a union called the Workers' Association Union. Workers' Association Union, which was established.
Your background as a trade unionist coming back now to give you a certain perspective about this name.
Yeah, you can imagine I couldn't stop laughing just at the attempt.
Similar to that other trade union called the General and Allied Workers Union.
That was a proper union which gave rise to what is today COSATU's largest affiliate, Nehau. Not this one. So I am saying we were told that this Workers' Association Union was established with the support of the Special Operations Unit of the SSA.
And its purpose?
The purpose ostensibly to neutralize the instability in the Platinum Belt and counter the growing influence of AMCU. The related operation or activity was the putting under surveillance of unions that had broken ranks with COSATU and which were critical of the president. That's what we were told.
I think General Workers Union of South Africa would have been much more imaginative.
I think
there
was a shortage of enlisting intellectual property. Yes.
Yes. We know that the Labour Relations Act deals extensively with the powers and functions of the registrar, the conduct of trade unions, and that is all left to the judiciary and the Labour Court to deal with. the idea that a secret and secretly financed project should be dealing with trade unions and the conduct of trade unions by supporting new trade unions, presumably at their instance. What does that say about the separation of powers principle?
Well, freedom of association, that's the issue. If people joined a union which is considered to be creating instability in the economy, it's the responsibility of corporate leaders to find creative ways of relating to that reality. That's the first point. And workers have got a right to associate with a union of their choice. Now, again, you will recall that this practice is not new. Whoever introduced this idea of forming a rival union using state funds must have been reading from the script of the apartheid times. You know, I was part of the leadership of the Congress of South African Trade Unions. I was working, amongst others, with the late President of COSATU, Elijah Bahai, and Jay Naidu. And we were shown their coffins whilst they were still alive. All this was brought about in the same way as this thing that we are reading about, what is it called? Association of Union or something like that. A project which is designed to undermine freedom of association, to create a sweetheart union. And by the way, this is not speculation, because you know for a fact that when the matter came before the courts, there was a settlement between the union and the SSA. But again, I don't think COSATU itself would have appreciated having to be protected in this kind of way from competition.
You know what I'm really not sure I understand in regard to this, you were saying we are aware that there was a settlement. Of course, that's because both Mr. Pretorius and I have read some affidavits that the public hasn't read. It just seems strange to me why a state institution such as SSA, or maybe a politician who is in government, if that is factually true, would say, let's take taxpayers' money and go and establish a union that must fight with that other union. And I can understand if maybe there was some connection with a COSATU rival union, but from what one has read, it doesn't look like there was any connection. It looks like it was something that just came from either some politician or politicians, or with a state security agency or state security agency. Just seems to be something that's just so far away. You know when you read your affidavit where it is said that state security, SSA, or some operation under SASA approached the media to say, we are concerned about how the president is portrayed of the government is portrayed. We want to influence the media to put the president of the government or the country in a positive light. One can understand that, it may be wrong, but one can understand why somebody would want that. But it's difficult to understand why SAA or some politician would want to say, let's use taxpayers' money to create a union that will fight with that union. I'm not sure. So there is that aspect. I don't know whether it's something you share as well or not.
Yeah, well, you know, unions exist because there is a particular labor relations framework provided by government. So if there is serious instability on that front, just like on any other front, in the final analysis, government will be expected to do something.
From the context, from the perspective of not wanting instability.
Yes.
Okay.
Yes.
Okay.
But that something has to be imagined. So if your imagination does not take you beyond thinking about causing the formation of a rival union, that's what you will do. As I was saying, it was done before.
Yes.
It is unfortunate that you could see a repeat of that in the post-apartheid South Africa. That is the problem.
Yeah.
Yes.
Okay. Good. Thank you. Mr. Pretorius.
Paragraph 7.16, Project Academia. What did you learn, or what were you told about that project?
Well, we were told that the project was designed to intervene in the Fees Must Fall protests and influence the direction of the student movement.
Again, the name there has been redacted.
The name has been redacted
and replaced by a pseudonym.
Yeah.
But you can proceed.
Yes, and the idea was to support what was called young bright minds, to be patriotic and to be strategically deployed to institute countermeasures and ensure stability in our universities.
All right, so let's just pause there a moment. The main agent in the project whose name is redacted for security reasons was sent on training.
Yes.
The destination of that training has also been redacted.
Yes.
The object or purpose of the project was to influence the direction of the student movement.
Yes.
And it was to support, quote, young bright minds, unquote, to be patriotic and to be strategically deployed to institute countermeasures and ensure stability and peace in our universities. Now, it may be quite legitimate to be concerned about peace and stability in universities, but the method used here, do you have any comment in relation to that and the freedom of association principle?
Well, what I said about freedom of association principle applies here. No need for the state to intervene in the manner that we were told this project was designed to do. And again, you know, the historiography of the conflict that took place in this country before we came to 1994 will tell us how undesirable this practice is. Again, I happen to know evidence leader, that you were part of the leadership of NUSAS. Huh?
Yes, I was.
So Craig Williamson is not somebody you don't know.
Correct.
You know what role he played in student politics.
Yes.
Um,
And I know the impact it had on the lives of people.
Yeah, and the impact it had on the lives of people. So this question goes to the heart of, in what sense of newness is this new South Africa new? And again, it's a matter, as I say, which I think this experience is saying to us, we must not think that we have arrived and therefore we can sit back and everything good is preordained to happen. And I hope that some of the recommendations we made will help to refocus once more the work of the decision makers in this regard.
Yes, the counter proposition that may be put, in fact, that the fact that this commission is sitting here to deal with these issues of extreme sensitivity is an indication of the strength of democratic institutions and our constitution. But you were going to make some remarks about that at the end of your testimony.
Please remind me.
Yes, I will.
Because I think it's important. Yes.
That is a remark that you wish to make, and I'll remind you at the end of your testimony.
Yes.
Paragraph 7.17, Chair, there will be evidence in due course of a report prepared by an operative during this period, which has become known colloquially as the Boast Report, in which the author records certain activities of special operations under his or her watch. And we have been given access to the report, and the State Security Agency have permitted release of that report without redaction. Initially, it was intended to redact certain clauses of the report, but after discussions, it was agreed that the whole of the report could be released. And 4 issues emerging from that report are dealt with in paragraph 7.17. Dr. Mufamadi, if you could just deal with them, please. It was a report made to the SSA DG at the time, Mr. Fraser, in February 2017, dealing with certain activities of the Special Operations Unit during 2016-2017. There are 4 issues that arise in your statement. What are those?
Yeah, well, this was called the Boast Report because the author was extolling the achievements of his group or unit. So it talks about what were called countering operations that were initiated during the 2016 ANC January 8 statement in Rustenburg. So the unit says we initiated 3 countering operations to impede the distribution of CR-17 regalia, impede transportation system of dissident groups from Gauteng province. And
CR-17 is a reference to the current president.
yes, the campaign for his ascendancy into the presidency of the ANC. The Then it also says, during the February 2016 State of the Nation address, the unit was, quote, able to infiltrate and penetrate the leadership structure of the Zuma Must Fall movement. The initial Zuma Must Fall indicated that more than 5,000 people would embark on parliament, but with efficient and effective countering actions and the dissemination of disinformation to supporters of Zuma Must Fall, only appropriately 50 Zuma Must Fall supporters attended the march, close quote. It's in the report that was tabled or filed by a member of the Special Operations Unit. It also says, during the ANC's manifesto launch in Port Elizabeth in 2016, the unit, quote, initiated a media campaign to provide positive media feedback through the placement of youth of various ethnic groups in photographic vision of media personnel, thereby promoting social cohesion, close quote. Chair, if you ask me what this last one means, I'll tell you I don't understand. So the report boasts of various other similar operations, including the, quote, active monitoring of the South Africa First Right to Know SAVESA.
SAVESA.
Yes. CASAC and Greenpeace was done due to the penetration ability of the group.
Right. In due course, if it arises in evidence of the Director General, the debate as to what is legitimate and illegitimate surveillance activity, one accepts that if there's a perceived threat to the country on any front, it's the duty, not only the right of surveillance organizations such as intelligence to see what is going on. Infiltration and influence is another story, but that's for another debate for another time. But the first three paragraphs, the interference in the CR17 campaign, the infiltration and neutralization of the Zuma Must Fall movement, and whatever is said about the ANC's manifesto launch in Port Elizabeth, whether clear or unclear, is that an example of political interference that would be prohibited by the principles in the white paper?
Yes, I think I'll put this in Zulu because I'm addressing the chair. This organ of state, such as the SSA, has no business to seek to influence Utingwani, also Salaningwati Edipi.
You'll have to give the gist of that in English.
No,
I understand it.
You understand
I
it?
understand it.
That's right.
But I think Mr. Pretorius wants to understand it too.
Yes, you see, issues of incumbency influencing who ascends, whether it's within political parties or even state organs, it's not the responsibility of SSA.
Yeah.
And as you say, the monitoring happens if you've got reason to believe that there is an intention on the part of the people you want to monitor to do unlawful things. And even for that, there are permissions that need to be sought. If part of the monitoring include listening into people's conversations and so on. So, as you say, evidence leader, I think the DG will have to spend some time indicating to this commission what exactly is within the realm of the permissible with respect to surveillance, but influencing things that happen in civil society, particularly organized formations, that should be a no-no. Yes.
Dr. Mufamadi, in paragraph 8,
Yes.
you refer to evidence that has also been presented directly to the chair in relation to the persons then named,
Yes.
Maklatuka, Njenje, and Sheikh.
Yes.
In relation, firstly, to a report given to the then Minister of State Security, Dr. Twele, and evidence in relation to a meeting that took place in the study of the President Zuma's private home in Pretoria involving Ms. Susan Shabangu and Mr. A.J. Gupta. You confirm that you were told and learnt of the events as you set them out in paragraph 8.1. Mm-hmm. We don't need to repeat them.
Yeah, I've heard that evidence.
Yes, you've heard that evidence. Mm. Then a matter that may not be a minor matter, that the oath of allegiance that SSA members are expected to take changed during the period under your investigation. Just briefly describe how it changed. How were members of the SSA expected to swear allegiance? And it may be more than symbolic.
Yes. Speaking from experience, I did take an oath of office. You are being sworn in as a minister. You swear an oath of allegiance to the Republic of South Africa, its constitution, and any law that is duly passed by Parliament, that kind of oath. And that is the oath you would expect not only ministers to take, but people who find themselves doing this kind of sensitive work. And as I understood it, it was really a similar oath that historically members of SSA took. But at some point during this period that was under review by the panel, the members were expected to take an oath which also binds them to profess allegiance to the Minister of State Security and the President.
Sorry, if I can just interrupt there. It would be to swear allegiance to the constitution laws of the country as per the original oath, but also now to the President.
And the Minister?
Yes, and then to recognize the authority of the Minister of State Security.
Yeah, sure. Oath allegiance to the President and recognize the authority of the Minister.
So this change, in terms of the oath, didn't happen during the period that your panel was in operation, but it happened during the period which you were reviewing.
Yes.
Yes. Was this a situation where this oath, the one you're talking about here, the new one, was it just additional to an existing oath? Normally, an oath might be a schedule to an act of parliament or something. Was this a separate thing in addition to an existing official oath, or was this the oath that SSA members took?
I will seek also the help of, because there is a copy that was shared with
Yes,
both the evidence leader and
yes.
So I can give you a copy of the old oath. Chair, both of these, the new oath
Yes,
is in the
Registrar,
bundle. I'll
please
give you a
assist.
reference. And I just want to hand to you the old oath. Sorry?
Sanitize before.
I
Yes,
think
but
I will,
it's for him, or have you got?
No,
Yeah,
no.
first and foremost. Because he
This
will-
is the sanitized oath.
Thank you. This is the old one.
Yes, Chair.
yeah, this is the old one which talks about the Constitution and,
Yes.
yes.
If you don't mind, without mentioning the name of the person that appears there, would you just read it into the record, please, as being the old one? I see that this was in July 2003 when it was taken according to what is at the bottom. Do you just want to read into the record so we have got it there? Dr. Mufamadi,
Sorry.
do you want to just read it into the record? This
Okay,
oath? Yes,
it reads,
without the name of the person.
yes, I solemnly and sincerely declare to be loyal to the Constitution, the Republic of South Africa, and the South African Secret Service, above personal interests, and promise to endeavor to maintain and promote in my work at all times the security of the Republic, to subject myself to the Constitution, to do my work faithfully with all my strength and using all my talents to the best of my ability, conscientiously carry out the corporate policies and procedures applicable to the South African service, promote the interests of the South African Secret Service at all times and above personal interests.
Okay, thank you.
It is actually dated July 2003.
Yes, I see that.
Yeah,
Just trying
because
to get the
it would be good to have,
Yeah,
the
to
new
see the
oath.
one-
Yes.
They will be placed in the bundle next to one another. Of
yes.
course. The new oath is in bundle YY2, page 32.177, and perhaps that can be read on to the record.
You said 32 point?
YY2, 32.177.
Oh,
It reads,
just 1 second.
You're going to have to
Oh. I'm sorry. Yes, I've got it. Yes, you can read it.
It reads, it's oath of office. I solemnly and sincerely declare my allegiance to the Constitution and the laws of the country, the President and government of the Republic of South Africa. I sincerely and at all times undertake to maintain and promote the security and safety of the Republic and its citizens to the best of my ability and knowledge. I undertake to contribute positively to the government's key outcomes of ensuring that South Africans are and feel safe, and that South Africa contributes to building a better Africa and a better world. Furthermore, I shall adhere to the principles of my profession as an intelligence officer, as well as the norms and values of a democratic society. I hereby recognize the authority of the Minister of State Security and undertake to promote the interest of the civilian intelligence service of my country above personal interests, and to guard and protect the integrity of my profession as an intelligence officer, as well as its methods and sources. I consciously undertake to carry out the rules, regulations, and directives applicable to the civilian intelligence service.
Thank you.
And in essence, what you say in paragraph 83 is that the panel was surprised by the introduction of the...
That's paragraph 8.3.
8.3, yes,
Yeah.
I'm sorry, Chair. In paragraph 8.3, you say the panel was surprised by the introduction of the oath of allegiance to the President and the requirement that the authority of the Minister of State Security be recognized.
Yes, we were surprised because we thought that this was superfluous to the needs of a democratic republic. And we thought also that it introduced elements that lent themselves to the disturbance of the balance of power and authority between the legislature and the executive. You know, it's to insist that employees of the state must swear this kind of allegiance is tantamount to saying, you know, you must express loyalty to your God, your creator, and immediately after your God, to me. You know what I mean? This is worrying.
Yes.
Yes.
Yes. The original or the old oath didn't, it seems, include allegiance, pledging allegiance to any individual, whereas the second one
Yes.
had included or introduced pledging allegiance to the President and recognizing the authority of the Minister of State Security.
Yes, but then you see, it takes us back, Chair, to what we were saying about if an individual in a position of authority gives me an instruction which is manifestly illegal. If I question that instruction, I will be reminded of the fact that I saw allegiance to that individual. This is the distortion to the relationship which it introduces. It then helps us to answer the question you were asking. Were operatives, members of the SSA, operating in an environment which empowered them to consider and respect the laws of the Republic as sacrosanct? Yes.
And which did the environment empower them to raise issues that they might think certain individuals didn't like to be raised?
Yes.
Yeah.
Yes, and of course, as you say, Dr. Mufamadi, the injunction not to obey an unlawful order is in the Constitution itself.
Sure.
Against that background, in paragraph 7.18, Dr. Mufamadi, you summarize the considerations which influenced the panel arising out of the evidence of projects placed before it. Would you place those conclusions on record, please? Para 7.18.
7.18, sorry, I'm going back to it.
Oh, are you going back?
Yes, to para 718. It's back a page, 2 pages, 1 page back.
Is it something you had overlooked? I thought we were at page.
No, I just wanted to deal with the oath first,
Oh, okay. No, that's fine.
and then to
then continue.
deal with the conclusion reached, because it stands in stark contrast to the oath.
Okay.
Yeah, but to the extent that we pointed to evidence pointing to the existence of Special Operations Unit as a parallel intelligence structure, serving interests of a faction of the ruling party and the personal political interests of incumbents. This would have been a direct breach of the Constitution, the White Paper, the relevant legislation, and plain good government intelligence function, which would then be an appropriation of a state entity in ways or for ends that run counter to what is contained even in the second oath of allegiance. In other words, I'm saying even the second oath of allegiance is internally contradictory to the extent that it correctly swears allegiance to the Constitution and it places individual incumbents at par with the Constitution. Yes.
Dr. Mufamadi, in paragraph 9 and all the subparagraphs under that head, you deal with the failure to implement financial controls in the SSA, and importantly, you deal with the absence of consequence management, as you refer to it. You did express some reservation that this detail of evidence should perhaps, or would be better perhaps given by someone closer to the SSA, and that evidence can and will be given in due course. But could you have a look at the evidence you give under this head in paragraph 9, and there are certain redactions necessary from paragraph 9.20, and I'll explain those in due course. But between paragraph 9.1 and 9.19, could you summarize that, please? Perhaps dealing with the failure to implement financial controls, the use of cash, and consequence management, and finally the Auditor General's role and your concerns in relation to that.
Yes, as we indicated earlier, that we were told that it was very difficult to implement financial controls in a situation where the movement of money was actually cash-based. And you had also this temporary advance where you are given money, you go and use it as you are implementing the project, and you come back later and say, well, I've done what I needed to do. You don't have to explain to the people who give you the money, I want more money. And there were many instances where there was no documentary evidence submitted to show what exactly the money was used for. And this matter was also corroborated by the Auditor General, who said the agency was not always able to provide documentary support for money used in operations. And he was very uncomfortable with having to write a report all the time which starts with a disclaimer of this kind. Because you are, as you can see, you are not talking about 2 cents. So this is what we were told. But as I said to the evidence leader, I think the operational people are best placed to give you the necessary details, having regard to the actual controls that they put in place, to start with their own assessment whether those controls were effective, and if they were effective, how come they were subverted.
You might not have looked into this because of the nature, high-level nature of your review and the limited time that you had.
Sure.
But it would be interesting to see whether in other jurisdictions SSA equivalence, whether this problem of using cash so much, or whether they suffer from the same situations as well.
Sure.
You know, I suppose that the first point they would make to try and justify is, for example, certain people that we deal with mustn't be known. And they mustn't be known that they are doing something for us, or they are giving us information, they are collecting information from us. And so that's why we can't, we have got to give them cash and so on, because there mustn't somewhere be proof that we are giving them something. Maybe that's where it will start, but the question is, how do you stop abuse? Because obviously a situation like that, is fertile ground for abuse, because somebody can keep on coming back and say, I've given him, I've done what I'm supposed to do with the money, give me more. You give them more, they come back and say, I've done what I was supposed to do with the money, give me more. Or they can end up saying, well, every month you are going to have to give me X amount. And because I'm supposed to do certain things and I can't tell you what those things are for the organization. And then every month they get this money, but they could be pocketing the money.
Yes, but as you say, Chair, our responsibility is to prevent abuse. Looking at examples in other jurisdictions, it's something advisable to do. But if we find nothing that helps there, we still have an obligation to think. You see, the late Auditor General was saying to us, you see, we get told that, yes, you can audit, but you don't have people in the Auditor General's office with the necessary level of security clearance to
look into certain matters.
Look into certain matters.
Only people with that clearance can look into, see certain things.
That's right.
Yes.
So the Auditor General says, no, look, if such people exist on earth, then between us and SSA, we need to find a way of getting such people into the Auditor General's office. And we then said, no, we think this is eminently reasonable. So we need to put this question of intelligence work beyond mystification. Because the best way to evade scrutiny is to suggest that the person who can do that is not yet born.
Because it seems to me that the country could easily have a situation where large sums of money are going to individuals who are not really doing anything for the country, and the country can't get to know that because of these excuses. And basically, large-scale theft can happen. Large-scale theft can happen.
Sure.
And we are not supposed to know, and we're not supposed to, because if we don't know, we might not be able to put measures in place to make sure it doesn't happen again. Ordinarily you want to know what happened, why it happened, and what kind of environment gave rise to it, made it possible for it to happen, so that you can then say what needs to be done to make sure it doesn't happen in the future.
Sure.
Yeah, okay. Mr. Pretorius?
Well, even where the theft of money was known, there seems to be a lack of consequence management. Perhaps you could refer the chair to the events described in paragraph 9.7.
As we keep shifting, my paragraphs are getting mixed up.
Page 21, black numbers.
Yes, Chair, you said 9.7, eh?
9.7, yeah.
9.7.
Okay, I think I'm getting there now. Sorry. Yes. Yes, one of the briefings we received as the panel was a briefing on the theft of over 17 million rand from a safe inside the SSA complex in December 2015. We were told that in spite of video footage of the perpetrators and the outcome of internal investigations, there appears to have been no consequence management because we kept on saying, okay, with these capabilities you have, what did you find? And of particular concern to us was the report the panel received that the head of the Hawks at the time, am I allowed to mention the name? General, well, there was only one head, Benning Ntlemeza, failed to take the investigation of the burglary to its logical conclusion.
Yes. Well, that's what you were told.
Yes.
We don't know that was finally the outcome, and perhaps we can hear more about that.
Yeah, possibly you will hear more about it,
Yes.
because as at the time, this is what we were told. It's possible that the matter had been progressed beyond what was at the time.
Yes, but it was a matter of concern to you.
It was a matter of concern to us because at that stage we were saying, this matter cannot just end there. Yes.
Yes, the detail of internal financial controls, firstly, whether to the extent that they existed were followed, and secondly, whether the financial controls were operationally sufficient to prevent theft and misappropriation. That will be dealt with in due course by witnesses before the chair. And it's important for him to consider what findings he might wish to make about what he hears in evidence. But just by way of summary, perhaps 9.13 of your statement to 9.16 would summarize the financial situation. If you could just consider that and perhaps place that on record.
Chair, point of exigency, is it possible to be granted a senior moment?
Well, I was actually thinking about that.
Oh.
I think let's take a short adjournment because we have just gone past 4 o'clock. Maybe there is also, let me just make sure that we all agree that we'll try and finish with Dr. Mufamadi.
Yes, we should finish within
We should finish quite
20 minutes to half an hour.
Yeah, okay, all right. Let's take a short adjournment, 15 minutes, and then we return. We adjourn.
You're so contemptuous of my unit.
Sorry, Chair. If I could just ask you, Dr. Mufamadi, to look at paragraph 9.6. And given the detail and the exigencies of time, I don't think the Chair will have an objection if you read that. Obviously, one name there has been redacted.
Please put on your mic, Dr. Mufamadi.
Thank you, Chair. You say the name has been redacted. I noticed that.
You wanted him to read from what paragraph, Mr. Pretorius?
Just 9.6. Your copy has the redaction, and perhaps you should also not mention the position, because the redaction may be useless without.
And it's
also
only one
redacting
name
the
that has been redacted in that paragraph.
The name in red. You can use the name in red. That is a pseudonym.
Okay. The panel received a submission from several members working in the finance department. They alleged that Dwayne,
Yes, and don't reveal the position.
restructured the budget process, leading to the collapse of the budget structure for domestic intelligence. The DG at the time was Ambassador Sonto Kujo. Dwayne removed all divisional heads and concentrated authority in his hands. This concentration stripped further powers from the Chief Financial Officer and effectively made Dwayne the budget controller for all the SSA, including the provinces. This concentration of power reduced transparency and enabled the movements of funds to areas of the SSA favored by the SSA leadership, such as Ambassador Kujo and Mr. Lomo.
Yes, now that may be the subject of further more detailed evidence, but that's as far as the panel is concerned.
Pen?
No.
You said
the panel.
Yes.
That I'm saying that there may be further evidence dealing with these issues.
Okay.
But as far as the panel,
yes,
the high-level review panel is concerned, that is what you learnt and recorded.
That's what we noted and recorded, yes.
And then if you could just please, and again, I'm sure the DCJ or the chair will have no objection, if you just place on record your observations in relation to the role of the Auditor General and what you were told by the Auditor General when you interviewed him. Paragraph 9.13 and following. And I'll stop you because there is a part at which redaction has once again entered the scene.
Yes, the Auditor General informed us that every year he is forced to automatically provide a qualified audit of the SSA. Firstly, this is because he's not provided with access to information to allow him to verify the finances and assets of the SSA. Secondly, he's not able to determine the extent to which performance targets have been met. This situation pertains notwithstanding attempts by the Auditor General and the SSA to develop mechanisms to enable a thorough audit process to be conducted. The AG's report on the SSA for the financial year 2017-18 provides a useful example of why the AG is forced to qualify his audit. He noted the high-risk environment within which the agency functions, and yet the manner in which expenditure and assets were recorded did not sufficiently mitigate the risks. He noted the extensive use of TAs, temporary advance,
yes,
for operations which were required to be certified for surety. However, during the audit, management was unable to provide documentation to verify operational expenditure of 125.6 million or that the money was used for the intended purpose. The AG was unable to confirm redundant assets in excess of 9 billion rand, as there was insufficient audit evidence and the assets could, quote, not be located by the agency, close quote. He, that's the AG, was unable to confirm the reported irregular expenditure of 31.3 million as stated in the financial statements. In addition, the AG has regularly made findings on the internal control environment. In his report on the 2017-18 financial year, he noted, for example, lack of consequence management and not holding staff accountable for poor quality of financial and performance reporting, inadequate internal review processes by management leading to material misstatements as required in section 40 subsection 1A and B of the Public Finance Management Act. Non-compliance with supply chain processes going unnoticed. Absence of approved standard operating procedures to guide collection, collation, verification, storing, and reporting of actual performance information. Numerous senior acting positions have been created, or rather have created instability, which resulted in delays in the audit of performance management. Lack of monitoring and implementation plans by the accounting officer and senior management to address key control deficiencies.
Then 9.18.
The panel
Or
recognized...
perhaps we shouldn't omit 917. My apologies,
Yes.
Dr. Mufamadi. Let's deal with 917 as well.
Deal with 917.
Yes, please.
The AG's report also complained about the incomplete assessment of the useful life of assets, which have recurred year after year as a result of information being withheld. While this is assumed to be because of SSA's reluctance to disclose this information because of the covert nature of the assets, it could also be because the agency is intent on hiding indications of serious mismanagement or rather serious management weaknesses.
And 918.
The panel recognized that the AG, as a result of limited access to information, could only provide a qualified audit and could not publish his annual report. And this was really a matter of serious concern.
Right. Now, from paragraph 920, Dr. Mufamadi, to paragraph 922, we are informed that that information is restricted and should not be disclosed to the public. Of course, the irony is that's the very budgetary arrangements that inform the grant of money to the SSA and how those are arrived at, they're secret. So now, of course, an irony arises in relation to supervision and accountability, certainly public accountability, but there it is, Chair. Those arrangements, for the present at least, are classified.
Yeah, well, I mean, what at least seems to be clear to me is that some of the things, you know, shouldn't be allowed to go on like this. There should be steps taken to stem the tide, to say, well, we are aware of this and it leads to abuse of taxpayers' money. A way must be found that will strike a balance between ensuring that legitimate work of this institution will be able to be done, but abuse and theft of taxpayers' money will be prevented, will not be allowed.
Let's take, for example, the notion that extraordinarily high amounts of the state's coffers are expended on national security projects or special operations. That wouldn't be known. One needn't reveal the detail of each project in such arrangements insofar as operatives and operations were revealed. But perhaps Dr. Mufamadi could comment on that.
Yes.
Why should budgetary arrangements be secret?
You're saying why should budgetary arrangements be secret?
Yes.
They ought not be secret. As we were saying earlier, a way has to be found, at least for the Auditor General to verify that the purported use into which this money was put, it's indeed what it was put into.
Yeah, I mean, it can't be that except those involved in using it or abusing it, nobody else can or should know. It can't be. There should at least be a category of persons or officials who can, or even if it's one category, namely the Auditor General. But it can't be that nobody has access to documents and information to say, was this money used for legitimate operations or legitimate purposes of the organization? It can't be, and one can see that one talks of large amounts that it just looks like somebody can just go and take, go away, come back and take. There has to be a way.
Yes. There are certain qualifications to the absolute rule of secrecy, but the position that I'm put in is that I've been told that the whole of the paragraphs shouldn't be placed before you. I think that this requires another intervention with the SSA.
Yes.
And we will do that and deal with it insofar as we are able later.
Yeah.
But I can't put the absolute secrecy nor the relative secrecy because I'm entering into paragraphs that I'm told I shouldn't.
Yes.
But be that as it may, 9.23 you can place on record because it deals with legislation.
Yes, and of course, there is a Section 2A of the Secret Act, Secret Services Act, which allows the SSA to keep any unused funds at the end of the financial year instead of disclosing and returning.
I'm sorry, Dr.
Yes.
Mufamadi, I don't want to forget this because I thought I was going to ask you a few minutes ago and I forgot. Did you get information as to whether, for argument's sake, the position is that since inception or since it was established, SAA, these problems that the AG was talking about have been there all the time and year in, year out. Of course, even before the establishment of the SSA, one would be interested in knowing whether the same problems existed with regard to the predecessor of SSA, the different organizations, or whether this was new, these problems that the AG was meeting when seeking to do their job. Did you get any sense about how long these problems may have been going? And once again, I accept that you had to deal with these matters at high level and didn't have much time to go into certain issues.
Relying on memory, the impression we had was that these problems were as old as the intelligence services. You know, it's this situation in which I was talking earlier about rethinking, reimagining things, and the rethinking and the reimagination does not go far enough. So you live with things which could be done better. That's the one point. But it seemed to us that special operations and to some limited extent PEN brought this defect into sharp relief. Otherwise the problem had been there.
Yes, yeah.
A low intensity problem.
Yeah. They just grew.
Yeah, it just grew.
Yes.
Yes.
And did you get the impression that somebody who was supposed to have studied the AG's reports in relation to SSA every year, and who was supposed to have said, look, there's a problem here, something needs to be done, may not have done that?
Yes, you know, I was saying earlier that there are these things that we do by way of convention. That's a no-go area. And it indeed becomes a no-go area.
Yes, yes, yes. And then it's worse if nobody's going to ask you whether you are doing your job in regard to that.
Yes.
Because everything is secret.
Yes.
Yeah.
Which then also, I think, when we come back to me saying what I want to say, it is important that the sacred cows are becoming less sacred. And I think we need to take solace out of that.
Because I would have imagined that the AG's report in regard to SSA would definitely go to the relevant committee of parliament, I would imagine. But obviously the minister concerned should know as well.
Yes, but you will have noticed in my earlier evidence that the AG, by way of complaint, was saying, I always started my report with
A disclaimer.
a disclaimer.
Yeah, yeah.
Yeah. And he didn't say there was a response to the disclaimer.
Yes,
Yeah.
yes. So the disclaimer became like a normal, so it's
Yeah,
not a
nobody
disclaimer really, it's fine. That's
Nobody
how it
took
is.
heed. In fact, it was regarded, it seems to have been regarded as, well, this is what is to be expected from a report in this functional area. You know?
Yes, yeah. Mr. Pretorius.
Thank you, Chair. Paragraph 9.23, would you just place that on record, please?
Yes, I'm saying in terms of Section 2A of the Secret Services Act, the SSA may keep any unused funds at the end of the financial year instead of disclosing and returning this to the fiscus, as all other departments must do. This means that unused funds from a previous year can be utilized the following year off budget. If funds are underutilized over time, a sizable pot may develop and has developed, which can be used without any disclosure.
This too is a matter of concern for the panel, or was a matter of concern for the panel.
Yes, in the same order of what we just discussed now. I mean, if I want to play truant, I just make sure that a big chunk of the funds is unused, and therefore it won't be accounted for. Yes.
You then, in your affidavit, Dr. Mufamadi, deal with the Principal Agency Network Program. Now, we know that that program was terminated or suspended in 2011.
Yes.
You say that in paragraph 10.1.
Yes.
And you say in paragraph 10.2, the essence of that program was the recruitment of principal agents outside the agency. And they in turn were trained and capacitated to recruit and handle sources who were of legitimate interest to the agency or could provide information to the agency. Do you see that in paragraph 10.2? And then you say, it appeared to the panel that PAN evolved into a methodology designed to avoid or bypass the procedural requirements for recruitment of staff, disbursements of funds, and procurement. Do you wish to expand on that, or is that sufficient as far as you're concerned?
Well,
What went wrong with PAN?
sorry?
What went wrong with PAN, the Principal Agent Network?
Yeah, well, I can just give an example of something we became aware of, namely that the panel became aware that one person was recruited into the PAN to provide analysis support. The analysis function does and should reside in the agency itself. So there was no need to get a temporary employee when there are full-time employees of the agency who should have the capacity and to deal with that function.
Now, there are several investigations, you say, that were conducted into the PAN program, and the results of those will be available and we can make available. But if you would just place on record 10.4 over the page, please. And perhaps 10.5, 10.6.
Yes. Yes, you see, the panel noted that the nature of allegations or accusations and the evidence collected during the various investigations painted a disturbing picture. Allegations of malfeasance, procedural transgressions, and criminal behavior were placed before the panel. This included, for example, the procurement of assets without adherence to formal procedures, the signing of fraudulent contracts and payments to persons without valid contracts having been signed, the employment of family members and close associates outside of formal processes, the abuse of assets and missing funds and assets.
Perhaps we should, for the sake of transparency, go on. I don't want to omit anything deliberately. 10.5, 10.6, and 10.7.
Yes, I was advised that there was a reduction there.
Yes, the last name in
Yes.
10.5
Okay,
is a pseudonym, so you can read what you see.
yes. In his interactions with the panel, Mr. Arthur Fraser confirmed the appointment of his son as an employee of a warehouse that was a front company for the SSA. He also confirmed initiating the employment of a relative of an employee of the SSA.
Okay, well put.
Okay, yeah, I had to make sure that I avoid.
Yeah, I see there is a position mentioned there,
Yes.
Yes.
Yeah.
and that could lead to the identification maybe.
And then 10.6.
It appeared to the panel that there had been instances of serious criminal behavior which had taken place under the guise of conducting covert work, and that this behavior may have involved theft, forgery and uttering, fraud, corruption, and even bordered on organized crime and transgressions of the Prevention of Organized Crime Act 121 of 1998.
Then you make an important observation in paragraph 10.7.
Yes. The panel was concerned whether the reporting requirements were followed by the responsible individuals in management when the allegations were discovered. This includes reporting of fruitless and wasteful expenditure to the National Treasury in terms of the PFMA and to SAPS under Section 34 of the Prevention and Combating of Corrupt Activities Act 12 of 2004.
And then 10.8 to 10.10, if you would place that on record. You deal again with consequence management in paragraph 10.8.
10.8 to 10.
10.
Of particular concern for the panel was that apart from suspending the PAN program in 2011, it appears that no formal action or consequence management has taken place by the executive or the agency management. The absence of consequence management has become a theme running throughout the agency over several years. The panel received reports that members of the agency's internal investigations team into the PAN project had been subjected to various forms of intimidation, and some had their offices broken into. The PAN program has had other consequences which seem not to have been addressed with the seriousness warranted. One such consequence is the large number of claims made against the agency and the Minister of State Security by former PAN members involving allegations of breaches of contract by the agency. These have amounted to hundreds of millions of rands.
Yes, we've collected some of these applications and their outcomes for the investigation files, Chair. But it's worth noting, Dr. Mufamadi, isn't it, as you informed us, that where the contesting of a claim in open court may reveal irregularities or even secret operations, the only real option for some would be to settle and to pay.
Yes.
And that has cost the fiscus millions of rands. Before we get to the conclusions that you wish to raise, may I ask you to look at paragraph 11. You make certain conclusions there that are important to place on record. And you also wish, I understand, to deal with the issue of public accountability and transparency. We have dealt today with many sensitive issues, which I'm sure many people would argue should not have been made public. And yet, in your evidence, they have been made public. That is a debate that may well take place in coming days, but if you could just tell the Chair what your views are in that regard, quite apart from our duty to deal with our terms of reference, which is not negotiable, but from your point of view, what are your observations? And any other concluding remarks you may wish to make.
Well, Chair, just to point out that the conclusions that are covered under paragraph 11, I actually dealt with them in the opening. So if
there's no need to repeat, sir.
There's no need to repeat those.
Yes.
But as I indicated to the evidence leader,
Yes.
I think notwithstanding everything that we were discussing here, which is quite disconcerting, it's important to remind ourselves that, as I said, this was a review of things that happened during a period that we were asked to review. So that what we are saying happened is not what we are saying is happening. But I think it will be instructive to wait for the Director General to indicate what it is that they did in response to the recommendations that were made by the panel.
And that evidence is to a degree comforting.
Sorry?
That evidence is to a degree at least comforting from the DG that will come.
Oh, he says it's comforting.
It's not clear whether you are commenting that it's comforting or whether you're asking him
me
to.
if I
No, I'm commenting. I'm not asking.
Okay, because I'm not privy to that evidence. And as you will have noticed, I tend not to seek to be privy to things that I shouldn't ask. The need to know basis, you remember. Yeah, so, but I think we are lucky that we still have what I call a residue of the will to introspect on the part of the powers that be. This is not an introspection for its own sake. And I think the report shows basically an admission that certain things went wrong. And to the extent that we were asked to make recommendations about how to avoid a repeat of those wrong things that happened, we must read in that a commitment to self-correct. But I think it will be wrong for the nation, beyond the executive, to sit back and watch whether that self-correction will happen. As I said, the legislative branch of government has no right to lower its guard. And perhaps we need to ask ourselves, particularly those of us who belong to various organizational formations in civil society, as to what kind of role should be played by the generality of the public in assisting the state to self-correct. Which is why I thought that it would have been the right thing to do for members of the public to say there is they call it the Zondo Commission. The Zondo Commission is having this hearing. We are happy that it's being aired in public, because it's when we become obsessed with secrecy, that we actually disempower our people from playing the role they must play to protect their own dispensation, which came at a heavy price. It's a price that those of us who know exactly how it was paid do not want our democracy to be taken for granted. Thank you, Chair.
Thank you, Dr. Mufamadi.
Thank you, Dr. Mufamadi. Yes.
Chair, that is the evidence. I must place two things on record, however, of a formal nature. I said in opening that Mr. Laurie Nathan was a member of the high-level review panel. In fact, he was a member of a previous panel, not the high-level review panel.
Okay.
And secondly, I also placed on record that the tape of the interview that the panel conducted with Minister Mhlobo was corrupted. I've been corrected. Well, that was the information I received from the investigators last night. That has been corrected, and the correct situation apparently is that the interview wasn't recorded at all, as others were, but that notes were taken, and I'm sure the SSA will make those notes available to us in due course.
Okay. Thank you very much, Dr. Mufamadi, for coming to give evidence and to highlight important features of your review and the report. I know that I'm still going to hear quite a lot of details about some of the matters that you have touched on today. But thank you very much. It's unlikely that we will need you to come back. I normally say to every witness, if we need you to come back, we'll ask you, but I think it's unlikely with you. But if the need arises, I have no doubt you will have no problem. Thank you very much for coming, and you are now excused. Tomorrow, Mr. Pretorius, do we have one witness for the whole day?
Yes, Chair, the Director General.
Okay, so we'll start at normal time, 10.
Yes, Chair.
Yeah, okay, all right. We are going to adjourn the proceedings for the day. Tomorrow I'll hear the evidence of the Director General of SSA. We adjourn.